Welcome back, everyone. We'll now begin our final panel of the workshop featuring the views of prominent economists who've studied the music licensing market. The panel will be moderated by Dr. Jeffrey Wilder, Deputy Assistant Attorney General for Economic Analysis at the Antitrust Division. Please proceed, Jeff.
Thanks, Karina. So as Karina just said, my name is Jeff Wilder. I am the Acting Deputy for Economics at the Antitrust Division. We are fortunate to have two panelists with us today, both of whom have substantial expertise in the economics of music licensing. First, let me introduce Professor Adam Jaffe of Brandeis University. He submitted a white paper on behalf of the Television Music Licensing Committee. He advocates in favor of retaining and possibly expanding portions of the decrees. Over the years, Professor Jaffe has testified for local television stations, cable television channels, and background music services and rate disputes and litigation against PROs. Our second panelist is Professor Kevin Murphy of the University of Chicago. Professor Murphy submitted a white paper on behalf of ASCAP. Professor Murphy advocates for removing certain provisions within the decrees now and eventually eliminating the decrees altogether. Professor Murphy has testified for ASCAP in rate disputes and litigations over the years, in addition to other clients. I'll start with Professor Murphy. So Professor Murphy, over the past 2 days, we've heard many opposing viewpoints. That's hardly a surprise, but I think there's two elements or two principles that we can all agree on. The first is a blanket license is a very efficient means of licensing many performance rights. And the second is when we do start to aggregate together millions of rights, there arises the potential for the exercise of market power. Where participants in our workshop would likely disagree is how well the decrees are working today in balancing these two opposing forces. So, Professor Murphy, my question for you is, what light can economics shed on what we've heard at the conference over the past 2 days, and how can economics help us better weigh the trade-offs that arise when we start aggregating performance rights? And you are on mute, I believe.
A couple of things. First, the idea that collective licensing or broad-scale licensing of the type that we've seen in this industry historical could be efficient because of the demands that users have and how they use music, as well as the blanket license, which, for as well known in economics, can allow users to create the most value from a given set of licensed works. I think that's well understood, as is, you mentioned, the traditional trade-off. While aggregating may be more efficient, it has the potential to create market power. I think the part that's really struck me as I've been listening is that most of the discussion is not about issues that arose because of collective licensing. That whether it's transparency or whether it's, music in a can or whatever else you want to talk about, those issues would exist absent collective licensing. And indeed, it's not clear collective licensing aggravates those issues. In many cases, if anything, it mitigates it. And so it's not so much about this trade-off we just talked about, at least most of the discussion that I've been hearing. If you were to split ASCAP into 5 pieces and DMI into 5 pieces, and they each had 1/5 of the portfolio they have today, I don't see which of these issues would be solved, even if that resulted in much lower. And that you can see that in most of the discussion that we just had. People talk about the problems that exist with the smaller new entrants. Clearly, that's not because somebody's aggregated large amounts of rights. And indeed, many of the points that have been made have been about pushing more rights into the larger organizations. So it seems to me there is that traditional trade-off, but that's not what lies behind much of the discussion.
All right, now I suspect that Professor Jaffe is going to want to weigh in on this question as well.
Yeah, thanks, Jeff, and thanks for inviting me to participate in this. Let me just say before I start that, as you say, I have in the past spoken and written on behalf of various music licensees. Everything I say today is just, I'm only speaking for myself. I'm not speaking for anybody else. So I'd like to pick up on one thing that Kevin said and then make my own sort of observations on the last day or so. I completely agree with Kevin that the issues are not about big PROs. In fact, small PROs that offer blanket licenses, that the issues of market power are still there. It's the market power doesn't arise from them being big. It arises from the fact that they represent a non-trivial number of individual rights holders. So I completely agree on that point. Let me just comment on a couple of things that I've heard over the last couple of days. I've heard a lot about new technologies, and I've heard a bit about sort of deregulation as a goal in some abstract sense. And I guess I'd like to just comment on both of those. In terms of technology, I mean, we can sort of dream maybe that someday there'll be algorithms and data processing such that you could imagine hypothetically sort of real-time, instantaneous clearing of licensee markets done by computers and algorithms. So you wouldn't have to have blanket licenses, you wouldn't have to have PROs, everything would be done between a rights holder and a licensee, title by title, second by second. And that's would be hypothetically a very different world that maybe technology would someday bring about. I don't think that's what we're talking about in the last couple of days. I haven't heard anybody suggest that that's really feasible. What we're really talking about when we talk about new technology, as far as I can tell, is that there are new vehicles and new mechanisms for delivering music performances to users, particularly through digital media. And as far as I can see, when I think about the economics of that, they don't really change anything. If you look at the digital licensees, the people who present music performances to users digitally, they look like they want the same things that television stations and radio stations have wanted. So it's just not clear to me, even though technology has changed, that it's a reason in and of itself why things need to change. And in terms of deregulation, I just want to remind us that deregulation isn't a goal in and of itself. It's a means to an end, and the end is increased consumer welfare. When we deregulated airlines and telecommunications, that was after literally decades of studies by economists and others that showed that the old regulatory regimes in those industries were raising prices and were hurting consumers. And I'm not really aware of any empirical analysis that shows that the consent decrees are somehow raising prices or hurting the users of music. So I'm not opposed to deregulation or talk about deregulation, but let's talk about what it would accomplish, not talk about it as if somehow it's an end in itself.
All right, so unless Professor Murphy has a response to that, I'll go on to the next question I have, which I think actually speaks to this a bit. So Professor Murphy, in your submission, you noted that regulation was common in industries with, quote, natural monopoly features, end quote. Since many users here need access to all music, is this industry a natural monopoly, and is that an important distinction to be, or is that an important way to, a useful way to be thinking about the industry and whether regulation is indeed necessary?
No, I don't think it really fits in that traditional sense because, first off, not all users fit in that category, but even the users that fit in a category where they demand a broad segment of music don't necessarily demand that from a single provider. They can assemble a portfolio from multiple sources. So, a demand for variety is not synonymous with a natural monopoly in the way in which it's being provided. I did want to follow up on one other thing, though, because I think the issues that we've been talking about would exist in the absence of PROs. I mean, they're not unique to the fact that these are intermediaries having multiple rights. Or, in fact, even if you divided the rights even much more finely, the issues that are being talked about wouldn't go away. In many cases, they might get worse. So what seems odd to me is that we want to try to solve these through consent decrees with particular providers in the industry. That seems to be, when you talk about problems that would exist anyway, a very problematic approach on how to deal with it. Now, deregulation isn't the goal in itself, but the thing that I think was also missed in the discussion is deregulation competitive markets have something very different than regulated markets. People don't do things in deregulated markets. It's about mutual gains. I don't do something out of the kindness of my heart. I do it because there's something in it for me. And the ability to gain mutual gains is what drives progress. You're doing it one way today. It's not so much would I gain or you would lose. It's on net. Do we both benefit net? Do I gain more than you lose? That's what's going to happen in a competitive market. And that's what deregulation often prevents, because that trade-off, if it's not recognized by the court, will not necessarily take place. That's one of the big problems you have under regulation. And initially, deregulation can redistribute between the two sides. But the thing it'll introduce almost always is that incentive to take advantage of the mutual gains. And I think we miss that often when we take a very short-run view to deregulation. It's not in and of itself, but it accomplishes things we may not even yet know we want to accomplish.
So I guess I would say that this sector certainly has some features of natural monopoly. I mean, ASCAP and BMI and CSAC all have systems that they've created to distribute royalties. They have computer programs that do that. They all spend millions of dollars on that, and those systems, are not half as expensive when you distribute to half as many people. So there are some features there. I think on the demand side, more importantly, if you look at the major users, whether they're traditional television stations and radio stations or digital users, it's true that they have licenses from ASCAP and BMI and CSAC, but they're not assembling some variety by doing that. They are just getting themselves the overall blanket protection that they need. They would all rather have only one blanket license rather than having to go to multiple different organizations to get blanket licenses. You don't see any of them going just to ASCAP and not to BMI, or to CSAC and not ASCAP and BMI. So to me, that looks a lot like there's features of natural monopoly there.
Now, do you want to respond to that, Kevin?
Yeah, I don't understand it from an economic point of view. The fact that people would prefer a single source if they could get everything they want from that source is not what we would call in economics a natural monopoly. You go to multiple places because different places are good at doing different things. That's why I shop at more than one store. I would prefer if I could get everything from one store at the same price I get now, right? I don't have an intrinsic interest to go to multiple stores.
But you don't see anybody going to Stop and Shop only. Everybody goes to all of them all the time.
Does that mean retailing is a natural monopoly?
No, I meant by analogy. In the music sector,
no, but
everybody.
The people want groceries and they want gasoline and they want all those things. That retailing is a natural monopoly, and it's just not what we.
I didn't say retailing was a natural monopoly. What I was saying is, by analogy, if music was like retailing, we would observe some people who shop at BMI and some people who shop at ASCAP, and we don't see that. They're not substitutes one for the other in any way.
They substitute over the long haul. I agree. At a point in time, you want variety, so you go to both. They have things at one that they don't have on the other. But that doesn't mean they don't compete on the margin, and they would compete more in a free market. In a free market, and particularly if it became more advantageous to license, they would compete to get more business. The gentleman from BMI earlier talked today. Somebody said, well, you just don't offer a discount. And you say, well, if there's nothing in it for me, I'm not going to offer a discount. But if I could say, look, if I give you a discount, I'll get a lot more business. Hey, now we're talking. And that's the kind of thing that happens in a competitive marketplace that's much more difficult to do in a regulated marketplace.
All right. Well, thank you for that. I do have a question now for Professor Jaffe, again, related to that discussion. Professor Jaffe, is there evidence that entry and expansion by other PROs like CSAC and GMR has increased competition between the PROs and led to better deals for users and songwriters?
Well, I think there's some evidence that it's led to better deals for some songwriters because CSAC and GMR have offered better deals to recruit songwriters. What they then do is they turn around and they license to the licensees, and basically what the licensee was getting before from ASCAP and BMI to reproduce that, it now also needs a license from CSAC and maybe GMR. And so the licensees are not getting any benefit out of that. As I said, they're not substitutes one for the other. The nature, and maybe there's a bit of a chicken and egg. It may be a bit of a result of how the system has evolved, but as the system stands today, you really need broad coverage because you need to try to avoid accidental infringement. And so the users want it all. It's not variety. They want coverage against infringement. And when it gets broken into pieces, they just have to pay more people more money to get the same thing. So I don't think there are benefits to the copyright holders. I mean, sorry, I don't think there are benefits to the licensees. There may be benefits to the owners of the compositions.
Right. So let me ask a follow-up to that, and that is, to what extent does this entry undermine some of the original efficiency justifications for the blanket license?
I think it does, and I don't disagree with Kevin that having, a bunch of these different PROs, some of which are covered by consent decrees, is not an optimal solution to the problems that we face. I think that, CSAC was sued in private antitrust cases, and, it tried to get out by summary judgment. That failed. The judge indicated that there was evidence that CSAC had market power by virtue of the repertoire it had, and then they settled. And how did they settle? They set up an arbitration proceeding, which looks a lot like a consent decree. So we do have a bit of a patchwork approach to this fundamental problem of collective licensing.
I really think we're missing the way in which these kinds of alterations to marketplace work. To me, it's very much like if you think about rent control. When you have rent control, the guy with the apartment says, "Man, this is great. I'm keeping my price down. Prices will be lower because we have rent control." And the immediate effect would be that very apartment that you used to have is going to go up in price. So if you look at that direct impact, it's going to be a higher price. But at the end of the day, how does it affect the marketplace and the incentives that exist on both sides of the market? The point is, people will now have an incentive to create more housing that will then benefit users indirectly. And that's what's so different that you got to remember happens in a marketplace that doesn't happen under regulation. And that, it's true, if you've distorted things through regulation, it's going to take time to undo that. What I don't see as the answer is to do more regulating. The fact that we see people coming in and, who have not amassed large portfolios, they have relatively small portfolios out of the total. They're coming in because there are opportunities there and market has been distorted in some ways. And maybe if the market was freer, they would have a tougher time because ASCAP and BMI would be able to hold on to more of that business. But, it's not, to me, a sign of a good place. And you don't want to keep adding to the regulatory environment. I always say the old adage, if you find yourself in a hole, first thing, stop digging, right? That's the number one thing when you're in a hole, stop digging.
But what is the empirical evidence that we're in a hole? I mean, people have done a bunch of studies of rent control and have really shown that it restricts construction of new housing. I know of no evidence that we're restricting the supply of music, that less music is being somehow written.
I don't even know if it's about the supply of music. It's about the alternative. People talk about, well, we need new licenses. We need different licenses. We need licenses that allow us more flexibility. That's the kind of things that won't happen very well under regulation. You talk in your paper about, well, I don't license directly because I can't get credit. And that's because the rate court won't give you credit. In a competitive market where you're negotiating with the guy across the table, If you've licensed more stuff on your own, you're going to get credit for it because he's not going to be able to demand what he otherwise could demand because you don't need him as much. That happens in a market by construction. And, when you talk about a lot of the things you talk about, they're implications of the regulation. They're not things that are being fought by the regulation. To me, I just was so confused by that.
Sorry, quick question for Professor Murphy now. Professor Murphy, different types of licensees use music very differently. As previous panels have explored, some users have a great deal of choice in the music they use, while others have less control and truly need access to everything. How does that observation affect an economic analysis of the market, and should the decrees apply similarly to these different kinds of users?
Oh, I think that's one of the problems. I think you would expect, given they have different circumstances in a marketplace, for them to end up maybe getting different contracts or certainly different terms based on their market conditions. We get some of that under the decree. Under the decree, for example, and you have the per program license in television that has pretty wide use that people use to engage in direct licensing. We have other forms of licenses that are available. As I see it, the problem is that's becoming an even more difficult task, right? Professor Jaffe talks about the ability of the court to set a rate. Well, setting a rate is one thing, but saying how much this license should cost relative to that license, that's an incredibly difficult task, and one for which outside observers, economists or courts, have a tough time doing. That's the thing that markets do very well. They decide what licenses will be offered based on this mutual gains from trade. If you gain more from that license than it costs me, we both have an incentive to get it. And we'll find terms that make it in our mutual interest to do it. Much harder to do in a regulated environment.
Any response to that, Professor Jaffe?
Well, I would just say, if we're talking about new context, so we're not talking about one television station versus a different one, but we've got a new platform, there's nothing in the consent decrees that stops ASCAP or BMI from proposing some new kind of license that has not been proposed before. All the consent decree does, or I don't want to minimize it, what the consent decree does is say, if they don't propose something that is attractive enough to the licensees have the right to sort of insist on a license, and the rate court ultimately may have to set the fee. But there's nothing that stops them from doing something completely new in a new context.
All right. Professor, Kevin, you had a response?
Just a little bit. I mean, it's not a question of stopping them. This question is what's their incentive. For example, as was mentioned in the previous panel, the similar situated requirement has an effect of affecting your willingness to offer something different. I'm actually surprised, given the DOJ's general attitude toward things like MFNs and things like that, that a requirement for a similarly situated clause would be something that would be attractive. I'm not saying similarly situated type clauses are bad per se, but generally don't think of them as being required. Anyway.
All right, Professor Jaffe, another way in which users differ is that even some users who desire access to a wide portfolio have flexibility in how intensively they use a given publisher's recordings. One such category may be services that provide background music for retail establishments, and another may be streaming services. Does the ability of ASCAP and BMI members to directly license such users provide a competitive check on blanket license fees?
Sorry, needed to unmute. Yeah, I think it does provide some competitive check, particularly taken in the context where ASCAP and BMI are prohibited from licensing exclusively, so that you can be a member of ASCAP and still have the option of licensing directly. As Kevin mentioned, we have things like per program licenses and adjustable fee licenses, which came about really because of the genuine choice provisions of the decrees. And those have, created some opportunities to work around the edges and to get some competition where it works. It doesn't work for everybody, but it does provide some competition.
I would agree that, the non-exclusive nature of licensing through PROs is an important part. I think I've been on record saying that throughout, that the non-exclusive nature of licensing, is really allows for multiple forms of competition. I don't think it's true though that the decree created adjustable fee type licenses. That is, many industries have things that look very much like an adjustable fee license, where you get a discount for using more of my stuff or pay a different price depending on whether you use more or less. Those kind of contracts are very common in many, many industries. They're difficult to do under the consent decree the way it was originally structured, so it took some changes to make that happen. I would expect to see those in a competitive marketplace. Now, whether people ultimately take advantage of them or use them as a negotiating tool, that's a different question. We do see that all the time, where threats to move volume, there are things that people use to negotiate better prices. The one thing I would say, though, you got to be careful. That is, contracts that involve those types of shifting of business in exchange for discounts do not imply that the prices for which they're discounting are not competitive. It's just not the case. As has been clear from the underlying economics, if I'm willing to give you more business, you'll be willing to give me a discount in exchange for that. That any deal at which somebody's selling above marginal cost has that characteristic, even when prices are competitive where they started. It's just a fundamental aspect of economics.
All right, thank you for that. Professor Murphy, does the current lack of repertoire transparency impede the ability of users to direct license or the ability of PROs to compete for song writers? What more, if anything, needs to be done to address this?
I'm not an expert on transparency. A couple of things I would say. I don't see why transparency is intrinsically tied to PROs even, or collective licensing as a whole. It seems like these transparency issues transcend that. And if we got rid of PROs tomorrow, transparency issues wouldn't go away. And I didn't hear anybody explain how it is the indirect nature of PRO licensing or the collective nature that creates a transparency issue if there is one. So that's number one. And indeed, it seems that if anything, the PROs are taking a lead in terms of trying to increase transparency. Transparency, again, it's not my area of expertise, but it isn't also the case as a matter of economics that one has to have all the information to get a competitive marketplace. In particular, you don't need to know the details of everything that's in if you can evaluate the whole. And in many cases, people can make a reasonable evaluation in the whole without examining all the pieces. But that's separate.
I would agree that in some sense transparency is an issue that transcends the PROs. I think the way it manifests itself, however, is that in the world that we're in, where particularly for audio-visual broadcasters and streamers, the music is embedded in a program that has frequently been pre-created, so-called music in the can problem, and they don't necessarily know what that music is or who owns it. The issue of transparency does create a problem for thinking about competition between hypothetically, say different PROs, because the broadcaster that might be thinking about choosing one over another has the problem that if they can't figure out who controls which music that they are already broadcasting, it makes that competition more difficult.
So you just mentioned, Professor Jaffe, the in the can problem. Should the decrees be modified to provide more or less licensing at the source? Would such licensing tend to foster competition, reduce holdup, and improve efficiency?
So, I'm not a lawyer, and I don't want to talk about exactly how you would do this in terms of the decrees, but I think it is clear that if more music were licensed at the source, over time, that in effect eliminates the in the can problem, because then subsequent users of recorded content would basically purchase the right to perform the embedded music as part of an overall license that they're getting for the recording. And so you wouldn't have that problem. And if you did have licensing at the source, it fosters competition, because at the time a recording is made, there are going to be many more options to think about different works that you might use. Whereas, once you've got the program in the can with music from many different owners and hard to identify, it makes competition more difficult.
I guess a couple of things I would add. I mean, first off, again, it's one of those issues that would exist if there were no PROs. It was all just, every music was licensed directly by the owners of the copyright. That, if you had no PROs, this issue would not, it'd probably be worse, wouldn't be better. So it's not a PRO issue, let alone an ASCAP BMI issue that should be addressed in those specific consent decrees. The other is, I think, if we move toward a more of a marketplace, and if there's a problem with people getting held up, that incidence doesn't just fall on the users. A lot of that's going to fall on the guy who produced the product, who's going to be able to sell it for less if you have to get expensive rights to go with it. And that would give them an incentive to license up front. But if you're in a world in which the rate court doesn't give you credit for that, then you lose that incentive. But the loss of incentive is not intrinsic in this ex ante ex post distinction. Because in lots of markets, I have an incentive to clear the rights for things. I want to figure out I own the land before I build the house, because the guy I want to sell the house to ain't going to pay much for it if it doesn't come with the land. And, we don't have that problem. The guys build houses on land they don't own because they want to sell the house. And, what's happened here is we've become, in many ways, dependent on the regulation that we've had. And you could say, well, geez, given we've had the regulation, that means we have to keep it, and maybe we have to expand it. I think that's a very tough argument to make, because it sort of says I'm never going to take advantage of the enhanced flexibility I would have if I could move away from the regulated environment.
All right, thank you for that. Over the past 2 days, we've heard reference to various types of licenses, including through to the audience per program and per segment adjustable fee. Professor Jaffe, are these license types necessary, and are they functioning well today?
Well, I think actually we've kind of talked about this a bit, so I'll just say, I don't know, necessary is a tricky word. I think they make the market work better today. They provide a vehicle for competition. They may not be ideal. And Professor Murphy sort of suggests that these things would evolve without the consent decrees. That's not obvious to me.
I would say if they're efficient, if there are mutual gains, they'll have a tendency to evolve in a free marketplace. And the problem is, under regulation, you lose that test. You lose that test that there are joint gains to the parties. because you have somebody sitting in the middle who can mitigate the ability to engage in that test. And, you know, but I do think that, you know, some of the flexibility that's there is the kind of flexibility that's valuable. And, you know, whether it's a per program license or the like, but it should be able to survive on its own merits, not because it's being imposed.
So a related question there. One area where I suspect the two of you may disagree is on the question of genuine choice. So a longstanding feature of the alternative licenses that we just discussed is that ASCAP and BMI are required to structure them in such a way as to provide, quote, a genuine choice to licensees. Professor Murphy, in your view, is this provision necessary and is it efficient?
Well, if you have a license form that would exist, then it will be a genuine choice. It should be a genuine choice and it should be priced as a genuine choice because it's efficient. The problem is if you say anything that I can think of should be priced in such a way that it becomes a genuine choice so somebody takes it, that would allow inefficient contract forms. It's sort of saying, if you invent a mousetrap, it's not a very good mousetrap, you should sell it and sell it at a low enough price that some people will buy it. And that's the problem. Now, I'm not saying that's what characterizes the contracts we see, because I think, you know, there are elements of the contracts we see that mirror what we see in other industries. So they probably make sense. But the idea that everything should, in equilibrium, be a genuine choice is at odds with economics, because many things should not be chosen in equilibrium and therefore should not represent a genuine choice.
I mean, historically, it was the rate court that sort of forced ASCAP and then BMI to offer some of these alternatives. Now, I think you're right. Then hypothetically, in a world with no collective pricing, if they're good, they're going to evolve anyway. I guess I'm not sure if the alternative world we're imagining is one in which we have no consent decrees and PROs are given an exception to Section 1 of the Sherman Act so they can engage in what they're engaging in, or whether it's one in which we just go back to they're subject to the antitrust laws, in which case I don't know what would emerge, but you'd probably have some antitrust cases. But the notion that we always get good decisions out of private actions, even when they're colluding, I don't think is what economics would support.
I would agree that that's not what economics would support. Although remember here, we have non-exclusive licensing, so that individuals do have the option to go in other directions. If you have the ability of other people to come in and the desire of them to expand, like we see with, you know, CSAC or GMR or other people, or even the publishers who want to license some of their stuff themselves, that gives us the ingredients that would undermine any attempt to have higher than competitive pricing. So I think we don't want to presume that, you know, there's never an antitrust problem. And I certainly would not advocate any immunity from antitrust. That's, you know, I'm not a lawyer, but as an economist, I don't see immunity as an answer here. But I do think that, you know, we see other marketplaces, in marketplaces where people want wide variety, whether it's sound recording or video or other places. Those markets work without the same restrictions we see here.
All right, thank you. So the two of you just mentioned the rate court. I'd like to do a little bit deeper dive on the rate court here, which will be the final question we have, and then I'm going to go to a couple questions I have from the Q&A. So we've been talking about direct licensing and alternatives to blanket licensing. To close, let's return to the pricing of the blanket license itself, and specifically the role of the rate court. What role, and I'll open this up to both of you. I'll start with Professor Jaffe. Professor Jaffe, what role should the rate court play in setting prices, and how close does the rate court today get us to market rates?
Well, I think the rate court plays an important role in setting prices because I think in the absence of the rate court, uh, I don't see why the various parties that own these rights would necessarily choose to compete rather than to collude. Now, you can say if they collude, then they're subject to the antitrust laws. But then we just have private antitrust cases instead of rate court. I mean, that's what happened with CSAC basically, and it was settled when they agreed to arbitration that looks a lot like rate court. So I don't see how we gain by not having rate court and instead, having a bunch of private antitrust cases running around. I think that, rate court isn't perfect and it's hard to sort of set rates by that kind of mechanism. We do it in other places. I mean, other copyright settings have copyright boards. We have patent cases where judges set reasonable rates because there are various kinds of compulsory licenses. So I don't think it's an impossible task. And I think it's maybe not the ideal, but it's not obvious to me that there's something better.
I guess I would say, Professor Jaffe mentioned that rate court is important for setting prices. I think they have been very important for setting prices. I think they, in fact, have been the major determinant of pricing in many cases because they really don't have market benchmarks to look at. And even things that look like market transactions are all done in the shadow of the rate court. If you have a license in which the supplier has to give you a license and the remedy is not to do without the product, but to go to the rate court and get a license fee determined by the court, that's a market in which the court is exerting enormous influence on the setting of rates, even if no case ever goes to court. It's very hard. And that's one of the promises of direct licensing, is that it would give you some actual market benchmarks, even for those who are subject to a rate court. But in order for them to be market benchmarks, it has to be a system in which it's either party can say no. That's what we mean by a market set rate, where a buyer and seller are willing. And willing means I can say no. It's not just willing to make a deal, it's willing and able to not make a deal. Those are important components. And that's why having more direct licensing, even if you maintain a rate court, is going to give you a more useful benchmark, a real market benchmark for thinking about what rates ought to be and what competitive market rates will be. And even if that leads to higher rates initially, doesn't mean that's where they end up. When you think back to things like railroad deregulation and the like, users said, oh man, the regulation is my friend. It keeps my rate below what that railroad wants to charge me. But when you deregulate, it creates incentives in the marketplace that change the dynamics that can end up giving people lower rates. It's not the direct, it's like the ultimate Chinese finger trap. You think you're pulling your fingers out, but they ain't coming out because the indirect effects are very different than the direct effects. And I can't stress that enough.
All right, thank you. I do have a question that came in, which I think is a pretty important one, which is, and I'll start with Professor Murphy for this. So from the perspective of the individual licensee, are songs substitutes or are they complements, or does it vary depending on the licensee? And is the answer to that question important to how we think about the economic analysis here?
Yes, and I actually spend a fair amount of time teaching this in my class, so I will. They are both, and that's not unusual. Most products that are related to one another have aspects of both substitution and complementarity. And that is definitely true in music, but it's true I give them in my textbook, I give numerous examples of car maintenance and cars and all kinds of things that are both substitutes and complements at the same time. And that's the situation we have here. And that's what markets, again, that's the point. You try to take advantage of the both substitution and complementarity as a buyer and as a seller. And that's why you need flexibility in how you structure your contracts. And that's often where the mutually beneficial deals come from, able to take advantage of one selectively. So I would say they're both. Many users want to combine music. That makes them complements. They have a choice over what to combine. That tends to make them substitutes. And you're right, not all users are the same. Some users, substitution is more dominant. For others, complementarity is more common. But almost for all of them, there's aspects of both.
So I would agree with that, but I would actually also add that at least for some licensees, it's important to realize that what they need is in some sense something more than songs. They need protection against accidental infringement. If there's music in a commercial, if there's music in the background at a football game, they're subject to statutory penalties if that gets broadcast and they don't have the rights to broadcast it. And that's, Professor Murphy was talking about the right to say no. They don't have the right to say no as a practical matter. They can't operate without that protection. And they need it in effect in a blanket mode, because otherwise they don't know when they're going to be infringing.
And that is due in any way to collective licensing, or is that about the copyright law? Would that be true absent collective licensing?
It is, no, I agree with you. It's due to the copyright law, which is one of the reasons why we want to have collective licensing. But then once we have collective licensing, we should recognize that the people who are engaged in collective licensing have market power.
I don't understand, because there's a missing step there. You're saying, I need this whether they have market power or not.
I didn't say that.
Allow them to go in collective licensing, they gain market power, and therefore they should be responsible for solving some problem that you would say exists even if they didn't have market power. So it seems to me them having market power has nothing to do with your argument. It's outside the chain of logic.
Okay, I don't think that's what I said, but let's go on because we're losing time.
Yeah, we are. So we are running out of time. I should thank the two of you for the discussion today. It's been great. But before we close, I want to give each of you the opportunity, if you want to say a few words or reflect on anything you heard, to sort of sum up or to reflect again on the conference. It's not necessary at all, because I think, frankly, we already covered quite a bit of ground in the panel.
I think I've said pretty much what I want to say.
Yeah, me too.
Okay, perfect.
Thank you very much.
Yeah, thanks so much for this. I've seen the two of you speak before, but it's great to have you in the same virtual room of sorts, going back and forth. I'd love to see the debate. I'm sure that everyone else at the workshop would agree with that. So with that, I will close the panel.